Hi, everyone. Welcome to today's episode of the podcast. I'm glad you're here. Today, we're going to be talking about the variety of processes that you can consider if you are faced with a divorce. And this applies to a legal separation or an allocation of parental responsibilities, which is for unmarried people who have children together who are breaking up and need to determine what the child allocation will look like in terms of parenting time, decision making, and the like. So there are a lot of options out there for you, and I know it can be very, very confusing. I know I, for one, get many inquiries each week, sad stories of people who are going through this, and they don't really know how to approach it or where to turn. And a lot of times when I do consultations with them, they will have done a lot of looking around the internet, trying to do searches where they're looking for ways to do this best for their children. Should I do this process or this process? There are a lot of sales pitches out there that try to tell you that their way is the better way to do it. And so I thought I'd unpack with you today what I think those general categories are and what I think is the best way to go about it, because the choices you make regarding the approach you use will really have a lot of implications in terms of what it costs you, how much stress you'll have, emotional stress, just mental health for yourself, stress on your children, stress on your future co-parenting relationship if you have children together, and just the way that you are engaging in something that can be just toxic to you and your family, depending on how you go about it. Some of these systems are much more adversarial than others. And so I just want you to have a really good sense of those different options so that you can think about the pros and cons of each and choose what is right for you and your family. I had somebody call me recently on a case where I had gotten off the case for a variety of reasons. And this person really just, had all of the information about the details of what was coming up. And very, very shortly, right before the hearing, which was months after I got off the case and had already made this all very clear to this former client, I was contacted with questions like, "Oh, can you just call the court for me and change that date? Because I don't think I want to do that date. I'm not ready." And it's like, no, that's not how this works. You can't just change it. I can't call for you, first of all. You can't do this close to this. There's certain formalities about filing motions and doing things like that, that a formal approach that needs to be done in order to handle cases in courts. You can't just call the judge. You can't just do it in a very loose way. There's a lot of steps you have to take and you have to follow the rules. So that's just one example of many I could give you of people just failing to understand that this is a formal process that needs to be taken seriously and that it really can go against you if you don't. So it's just important, if you're doing it yourself, you really consider that and you own that. Also, when people do it themselves, there is a much higher risk that there will be mistakes made in the financial division, which can be very costly, and not understanding, for example, aspects of separate property consideration. So you have to be very, very careful you're being precise. Also, uh, sometimes we don't even have sufficient disclosures done because people don't understand what should be disclosed. You have certain rights to get information that you might not understand. And so, again, if you're going to do it yourself, you need to be really careful that you are educating yourself so you do it well. I think also I've seen that there are a lot of different things when people do it themselves that they don't understand regarding child support and alimony or maintenance. So that can be an area as well where people are really faltering. Now, the courts are a little more careful about that because they want to make sure that pro se parties who are doing this themselves are adequately informed about their right to maintenance and things like that. And child support cannot be waived, but even if you're not paying it immediately, it's something you can go back and get. But still, there's a lot of mistakes that can be made. So you just have to be really aware and make sure that you're properly researching the considerations that you need to look at and think about and be informed of when you're going to court on your own. Getting a lawyer is adversarial by nature. It therefore, because of the cost and the adversarial nature of it, can be very, very stressful. Very much feel like you're in a war and that you are on one side and that the other party is on the other side. So the stress can be very, very high. It can be very draining emotionally on you and your spouse or partner. and very damaging to your children when they are not prioritized by the lawyer, or you start to believe the lawyer that the children are not the most important thing. Now, most lawyers aren't going to come out and say that to you, but there's a surprising number of attorneys who don't prioritize the children. And that fighting about money and assets and other things spills over and affects the children in just such really dramatic ways. And you've heard me on this podcast talk a lot about adverse childhood experiences, ACEs. There's a lot of research that shows that even in adulthood, children who experience divorce, particularly toxic divorce, have there's a link between that experience and negative health consequences, physically even, and certainly emotionally, to children now and in their adulthood. What I have found, and I'll offer as an alternative to all of these, so this would, I guess, be our sixth way of doing it, but I think is potentially the best way, is to use an offering that I'm calling Amicable Uncontested Divorce Solutions. This is something that we have created in my firm, and I hope others will begin to start adopting as well. It is starting from soup, going to nuts, starting from A, going to Z, with an attorney, with both parents, and having a very highly curated, customized approach to work with both of you in a way where you are known and potentially your children are known. And we are customizing solutions to meet your needs, the specific needs to your family and your children. I'm going to go through why I think this is better, and how it's different. So, first of all, it's full service handholding. You don't have to understand the Greek of the legal language. You don't have to know your own deadlines. You don't have to chart and navigate this on your own. You have an attorney who is skilled and experienced in family law and in child advocacy, and her team helping you navigate this and doing so in a very handholding way. Um, Secondly, we work with both partners from the consultation all the way through the case and every step in between to find specific solutions customized to your family. Thirdly, it can be far less expensive because you're using one team and you're doing it together. Again, you ask how much. It's really hard to know because it depends how complicated your case is. It depends if we need to bring other people in to help for expert help, or how long the case takes, how complicated the assets are, how complicated the child issues are. I can say that it is far less expensive than having an adversarial approach with two attorneys. Next, it's guided really importantly by a licensed lawyer who is an experienced family law attorney and who understands the nuances of the financial aspects of divorce, of various options for assets and debt division, separate property components, um, gifting, and various commingling considerations, all of these sorts of things. And very importantly, who has done child advocacy and understands the developmental needs of kids and other needs of children and has creative ways to approach this. In that way, then, the process is informed by years of that specific work and informed by years of negotiation, training, and practice, being in the seat of working with people to navigate um, the settlement options for people and the entire process. And very importantly, somebody who just barely has gotten engaged in your case, who is just doing a couple hours of mediation or not hand holding this so much for you, they have not earned the right with you to be able to push back on you. A lot of this is highly emotional. Working with your, the opposing parent, can be very adversarial. And I find myself oftentimes where I have attorneys who will say, there's no way this case is going to settle. And I'm able to come on as a child's legal representative, work with everybody together, earn the right and the trust to be able to speak some truth into people's lives about what we can consider and what their children might need. And then be able, in a way that attorneys previously have not been able to because they're too entrenched and they're too they don't understand the other parent's perspective enough. And when that happens, when I get into that seat where I do know all of these things and I know these people, I've earned the right to actually be a little bit probative in terms of pushing back and saying, I need you to not talk like that right now. I need to move us into different Zoom rooms, or I need you to approach the way you're doing this a little bit differently, sir or ma'am, or whoever you are, because you're derailing this. And the reason is because I know this about you. And let's talk about why this is happening. So you earn a relational right in this full service, kind of amicable, uncontested divorce service, where I have the ability to push back on people and to be a trusted partner in the process, where another mediator arbitrator really would not have earned that kind of right, because they don't have the depth of knowledge of the case or depth of knowledge of the relationship, and they don't have the credibility necessarily from having been both the attorney and the child advocate, the financial person, to be able to address all these things in a credible way.